Okay, here's the deal. William Torres Morales. We want everybody to see him and remember him. He was locked up in the county jail by our detectives for 6 counts of child abuse for tasering children, and it was aggravated child abuse, tampering with physical evidence, and we came back and charged him with 2 counts of sexual battery on a child less than 12 years old. In fact, the child was 7. He was not the only one that was charged. We talked about this at a press conference. One of the folks involved pled to 20 years. One involved pled to 10 years. But 2 independent psychiatrists appointed by the court deemed him incompetent. Now, the state attorney still has the charges pending, and neither the state attorney nor us at the sheriff's office have given up. However, the judge, according to law, had to release him pending education and therapy. Had to release him from custody. As it was explained to me, he was not significant enough to be sent to Chattahoochee, which would keep him in custody, until they dealt with him and then brought back. But in fact, he was released to the community.
That's the state mental hospital?
State mental hospital. Once he was released into the community, we did a telecommunicator message last Friday afternoon to a 1-mile radius around where he is living, and we put the community on notice. We also went to the house where he's living and talked to him and his dad and said, look, we're telling the community where you live because we think you're a danger to society, contrary to what the psychiatrist said. And we think he's a danger to society because he clearly has committed aggravated abuse on children and sexual battery on a child 7 years of age. We also told them that should anyone from the community come there to bother them, lock their door, dial 911, and we would come protect them. We're frustrated with the law. I have talked extensively with the state attorney's office. In fact, the state attorney, Brian Haas. Brian Haas is equally frustrated, but that is the law at this time. Now, here's how it's explained to me. That when the issue of competency occurs, the court appoints, based on a rotating basis of those who have signed up, 2 psychiatrists. Both of their opinions concur. And as a result, they deemed at this time he's not competent to proceed. That's why he's released. But he is receiving therapy and education, and the state attorney's office still has these very heinous charges pending against him. So he's not out from under the criminal justice system. But what frustrates me, we've got what I believe to be a very dangerous person in the community until it works its way through the criminal justice system. So I don't blame the judge for his ruling. I certainly don't blame the state attorney for what he or she had to do, but we need to relook at the law because I think it's problematic. So that's the state of William Torres Morales. We're not giving up. He needs to go to prison for the rest of his life. He committed 2 counts of sexual battery, 8 counts of aggravated battery against a child abuse, and the investigation goes on. Community, beware. He's out, and he shouldn't be.
Sheriff, typically in a situation like this, if they were convicted of those crimes, they'd obviously have to, and they were living out in the open, you know, with the general public, they'd have to register on the sex offender registry. In this case, they're not. What are some, I mean, that's got to be frustrating because your hands are tied.
Well, first off, you bring up a good point. First off, if this guy was convicted as charged, he would have a life sentence. He would never be out of prison, number one. Number two, if he pled to anything less than that, he would be designated as a sexual predator or sexual offender, and we would have restricted areas where he could live. In addition to that, we would be actively tracking him. But none of those things are currently occurring because he's not been adjudicated. The judge put some restrictions on him, and the state attorney's office went back today for another hearing, and the judge added another restriction, which we're pleased with, in that he now has to wear a GPS. So we are keeping track of him as well as we can. I've also instructed my criminal investigations division to change our protocols so that anyone that rises to this level of danger that's released pre-adjudication, we plug into our system so we can track him as well. But the reality of it is he's dangerous and he shouldn't be free, but that's the system as it is today.
So I think the point is you didn't have to notify neighbors. You didn't have to put these restrictions in terms of stricter monitoring through the sheriff's office. You did this out of public safety interest.
Absolutely. There was no requirement by law that we notify the community, that we go to his house and check on him. He has to check in with the court as to the guidelines prepared for them. We went above and beyond because it's the right thing to do, and it's never difficult to do the right thing. That's why we notified the community. That's why we also are changing our internal protocols, that even though there's no obligation and even though there's no requirement, that we're going to go above and beyond and track these people while they're out on this suspended status pending the end result of the case.
What can you do moving forward legally? I know you're saying you can track them, but how far can you go to make sure that, you know, he is home?
What we can do is we can ensure that he complies with a court order. It's the order of the court that he do this. But there are no time limitations on this. So we are taking the court order and we are ensuring that he follows all of the stipulations set forth by the circuit judge. And that's all we can do.
And how would you track him?
Well, when he has to put the GPS on, we have, through our county actually monitors the GPSs for those that are GPSed, but they will monitor his conduct. And if he travels any place in violation of this, then we'll violate him and put him back in jail. Or request, we can't unilaterally violate him. We have to go to the judge and ask the judge to violate him and put him back in jail.
And I know we touched on this during the press conference, but sexual battery, and he's accused of literally torturing at least 7 kids with a stun gun.
Now, here's the frustrating thing to me. We know that he has a proclivity to hurt children. He's demonstrated that over and over, from aggravated battery with a stun gun to sexual battery of a child. And it makes me very angry that he is not locked up. So, we're going to do the next best thing. We're going to put a fence around him as much as the court order will allow us until he's hopefully back in custody and sentenced. We're serious about this case, as is the state attorney's office. They've already accepted a 20-year plea, a 10-year plea, and the guy who's the most culpable right now, the psychiatrists are saying, oh, he's not competent to proceed. Well, he was competent to sexually batter a 7-year-old. He was competent to commit aggravated child abuse, and I got a jail that he's competent to be in. And that's where he needs to be.
Do you know if his competency status can change?
His competency status can change. That's why the state attorney's not dropped the charges. He has to be educated and there has to be therapy, but certainly his status can change.